A very warm welcome to all the participants and today to our webinar on top causes of claims and disputes in construction infrastructure space. Now, obviously, if one says top causes, today the top cause in anyone's mind will definitely be COVID. But I think we have already done a session on that. And if that is on anyone's mind, you can always look up at our previous session on that aspect. But we are, as you know, as Devanshu introduced earlier, we are joined today from some experts from across multiple jurisdictions spanning UK, Dubai, Singapore, and India. So with the expertise of expertise from so many jurisdictions, we are going to discuss top causes of claims and disputes generally being seen across the globe, with certain focus obviously on India. And with that, I'll probably sort of start today in a different manner than other sessions that we have done. On our topic, we have created a small poll question, which will come up on everyone's screen. In that poll question, the poll question essentially is, what is the biggest cause of a claim or dispute in construction projects? And we have put forth certain options there. And obviously we invite all the audience to answer them. We have not included any option in terms of COVID, or none of the above, or all of the above, or a multiple choice. We ask everyone to apply their brains and pick one. I know there may be multiple causes which everyone faces, but we just want to see what comes first on your mind or what you perceive to be of the biggest concern. COVID itself is an issue, but it leads to certain other problems as well, such as labor force issue, availability of work site, and supply of raw materials, etc. So in that context, we started go down a step further and see what is that issue which is causing the delay. So with that, I think the poll question will be up on screen for everyone, and we let that be there. And while you are taking the poll question, we'll come back to the responses a bit later. But while you are taking up the poll question and answering that, I will now invite Benjamin from HKA to come in. Benjamin will basically be, HKA as part of the organization has created a report and has done an extensive survey from across jurisdictions across the globe on what they have found to be the top causes of claims and disputes. So while we run a short poll on the top on that subject for our audience, I'll probably invite Benjamin to sort of deal with the entire detailed study that they have done and what observations they have to share. So at this, over to you, Benjamin.
Thank you so much. Let me just get my slides up. So hopefully you can all see my slides now. Ashish, can you see those? Great. It's a timer, so I keep within our time. It's a great pleasure to host this seminar together with LifeSpace developers, NDA, the Society of Construction Law, and RICS, four very esteemed organizations. And I'm delighted to be here presenting predominantly to an audience in India. I'm going to talk very briefly, 8 to 10 minutes, on claims and dispute management, some lessons learned. I think you all know HKA. We are listed as #1 provider of construction experts in the world in Who's Who Legal, and we're also highly regarded in Global Arbitration Review and the Academy of Experts. I'm a civil engineer. I'm a fellow of the Chartered Institute of Arbitrators, and I've practiced in claims and dispute work for over, believe it or not, 20 years now. I know I look quite young, but sadly it is over 20 years now. And each year HKA gathers information from across its projects that it's been working on. This information remains anonymous, but we analyze it, we filter it, and we really try and understand what are the principal causes of loss and expense and delay to projects across many, many sectors, including buildings, power, infrastructure, ports, oil and gas, both upstream, downstream, offshore. We analyze the causes to try and understand how contractors can learn from the lessons of the previous year and how they can improve in their approaches to delivering capital projects with commercial success. And what we found, specifically looking in Asia from 2020, is that a number of causes are quite similar in different jurisdictions, but there are some some causes that really stick out. And if we really focus on India on this chart, we've looked at 10 projects with a capex value of over $2.1 billion. And from the about 35 underlying causes of delay, 22 primary, 13 secondary, we found that really the principal cause of disputes in India is quite simply a change in scope. So this is really where a scope is not properly defined before the project is kicked off. Parties have not done their due diligence, and one might say that they fast-tracked these projects. I think a good lesson can be learned straight away here, that you may wish for your rail project to be put in place or your power station to be mobilized, but really rushing projects prior to them being ready has an exponential effect on the result. Secondly, access to site, a big issue particularly in a COVID year where sites are not being procured and released to contractors on time. And other issues that are highly ranked are products and materials delivered late. I think that is a result of COVID, where procurement problems have been endemic. Sadly, cash flow, payment issues, simply not being paid on time. And then really from the contractor's side, contractor's risk really is poor management of subcontractors in the supply chain and the interfaces of that supply chain. And when we really look at 2020 numbers again, and we look at the number of projects that we've been involved with, 19% of disputes were settled, 40% of disputes were not settled. And when I say not settled, I mean they failed to settle at that stage. And so they were only left with arbitration. And the balance are ongoing. So we sit in an environment, this teaches us that we sit in an environment where disputes are simply not being settled quickly. And so typically a dispute crystallized is taking more than a year to reach a point of resolution, which is a problem. It's a huge problem in our industry. And when we look at how projects are being resolved in 2020, of the projects we've been involved with, the vast majority of them are either in negotiation, in this case 14 projects, but we can see a huge move away from high court litigation, the traditional way of resolving disputes, towards arbitration. And this is results in Asia as a whole. And so arbitration is really becoming preeminent and predominant in the market. Sadly, adjudication is very low, and adjudication is something that really is still in its infancy in Asia. And it's something I would love to see more of as part of a remedy for dispute resolution. For those of you who don't know, adjudication, it can be a 28-day process. So it's a very quick process, and it deals with some of these problems associated with the timeline. So what are we facing? What are the causes and what are the remedies? We're looking specifically at 2020, a COVID year. Some of these main causes are in and around shutdown, work stoppage, social distancing. Seems like a pretty basic thing, but it's causing a lot of reduced productivity. Increased health and safety. It's a good thing, but it's been doubled up, so much so that we have significant reduced productivity. And of course, curfews that have been placed on and off in India. From the employer's side, we're really seeing a lack of employer supervisory staff and decision makers. So some of the drawings, engineering matters, access to site arise because the employer simply cannot mobilize teams to site. Now, of course, the impact can be immediate. It can have an immediate effect on the project, slow down or stoppage of ongoing construction. But I think a big part of it is an ongoing and a future impact. So how do you analyze it? What do you do? Do you look at the past? Do you focus on now? Or do you look into the future? Well, I've just got a couple of tips to finish off with for my time slot. And for the audience here, we can flesh these out on another occasion, but 7 key tips from me. Simple one, compliance with your contract. Your contract is the guide by which you run your project. NDA can tell you all about it. Make sure you comply with notifications and detailed particulars. Keep excellent contemporaneous records. That word contemporaneous means real records, not Excel spreadsheets or letters that talk to the problem but don't evidence it. I'm talking about photos, I'm talking about signed drawings, I'm talking about primary project documents. These are contemporaneous records. And prepare and continually issue detailed particulars of delay and financial loss. Don't wait till after the effect of the event is known or at the end of the project, but communicate with your employer. And if you're an employer, demand it of your contractor. Make sure the particulars are delivered in a timely manner. And don't do it in isolation from one another. Come together as an employer and a contractor. Communicate, agree an approach, work in partnership. It's in your best interest to do that. And it doesn't mean that you're going to be overly generous or overly burdensome, but it's important to communicate. Link the cause and effect. Don't just come to your employer and say, it's COVID, you owe me money. I'm afraid that doesn't follow. You have to actually link the effect of the cause complained of. It's absolutely fundamental to agreeing a settlement on matters that are in dispute. Use technology to establish a case. The construction industry is, frankly speaking, in the dark ages. So engage with technology. Use SharePoints, use web-based platforms, use software such as Primavera, use cloud-based systems. Join the dots and make sure the thinking comes together using modern technology, because modern technology is going to deliver you a solution. Gone are the days where you could work through Excel spreadsheets to get where you want to go on a project. And the final thing is, if in the event that you do have to go to arbitration and hope to avoid it, but sadly it does happen, invest in the arbitration, get the best experts, make sure you prepare yourself, gather the right records. Don't launch an arbitration prematurely without having done your homework. And if you do that, then an independent and impartial tribunal will give you a fair result. Thanks. That's all for me. Delighted to speak and looking forward to hearing from the panel on questions. Back to you, Ashish.
Thank you, Benjamin. I think what you pointed out here at the end is obviously extremely critical. And it's also interesting to see the causes that your survey has brought out. And on the last point that you said, invest in arbitration, being a lawyer on the panel here, I'll definitely have to sort of echo it and support it and make sure it's known, because what you have said earlier, all the points are equally important, but once you have done it, your investment in arbitration automatically becomes lower. But at the same time, if you invest there, the outcome is also quick and efficient. With that said, we'll probably move further. And I see we have kept the poll questions. We have responses coming. Most of the people have responded, but we'll still keep it open for a bit more and probably announce the results at the end. So we'll keep the poll running, and with that, we'll move further. And what we saw Benjamin obviously explaining as the first part, the top causes of claims and disputes and the reasons that he highlighted, all of these in one way or the other lead to certain delays. So now that we come to delays, if the question is, and last point that Benjamin pointed out was invest in arbitration, but what happens in the arbitration? You are resolving these disputes and identifying legal solutions or the legal answers to the claims issues that you're facing. All the issues or all the aspects have led to certain delays. So typically, all these claims would involve certain level of prolongation claims. And that brings us to my presentation on this subject, which is delay claims in the Indian context. I'll just share my screen as well over here because I have a few slides. Mukesh, if you can help me with that, and so I can proceed with the sharing the screen. Thank you. All right, I think that's visible for everyone now. So when we speak of delay, what is it that we are looking at? Typically in contracts, when delay happens, there are three things or three consequences which can flow. Either the delay could result in an extension of time, that is, there's an additional time granted to the contractor to complete the project, along with whatever cost that the contractor incurs for that project is granted is given to the contractor, or for that extension of time is granted to the contractor. Second is that if a delay occurs, the contractor only gets extension of time, but no prolongation costs. And the third is when the contractor is not granted any extension of time, rather the delay is on account of the contractor, and the employer claims damages, which is typically provided in form of liquidated damages. So these are the three consequences which delay typically results in construction contracts. And what we do is we look at a contract, we identify the delay or the cause of delay, and we look at how the risk allocation has been done within a construction contract, and see what is the solution, or what is the sort of result or remedy that the contract provides in context of a particular delay. For example, variations or change in scope, which was highlighted as one of the prominent or the biggest reasons for a dispute in context of India, typically would allow both an extension of time and prolongation costs. Along with there are certain other factors. For example, in FIDIC contracts, you will see that force majeure claims, certain types of force majeure claims only allow for extension of time. Even pandemic like COVID may in certain contracts only allow for an extension of time without any prolongation costs. And lastly, liquidated damage, which is, as I said earlier, is typically contractor-related defaults, which could result in liquidated damages being claimed by the employer. So these are the three consequences which are normally provided in contract. But what is it that is provided in law separately? If we're not looking at the contract, but we are looking at the law otherwise, and that is the contract law in India. Now, in this context, Section 55 of the Indian Contract Act becomes relevant. One should keep in mind that unlike other common law jurisdictions, the law or the contract law in India is codified. And to that extent, there is a statutory provision governing what happens if you fail to comply with your contractual obligations within the specified or agreed times. In this, Section 55 basically states that there or gives two situations. A, where the contract or time is of the essence for the contract, and B, where time is not of the essence of the contract. In the first situation where time is of the essence, it says that failure of a party to perform the contract or their set of obligations within the specified time would allow the party to void, or can allow the party to rescind the contract if they choose to do so. And if they don't choose to rescind the contract or treat the contract as void, they can continue with the performance or accept the belated performance of the other party's obligations. Then in such circumstances, they have to perform their own obligations. They will not be able to claim any compensation or loss due to such delay in performance. Only thing is they will be able to do so if in the situation or if at the time of accepted belated performance, they actually gave notice of their intention to claim such compensation. And in situations where time is not of the essence in a contract, then generally a party is only entitled to claim compensation, but there is no claim or there is no option of actually rescinding the contract. In case of construction or in the domain of construction industry, what we are looking at today is if there are situations where delay is caused by the employer, then or by other third party or other factors, but not factors which are attributable to the contractor, but factors otherwise, then what happens? If we apply what is given in Section 55, the answers we come to are as following. If the time is of essence, then there is a delay by the employer, then contractor can rescind the contract and claim damages. Alternatively, contractor can choose to continue performing the contract and notify the employer of its intention to claim compensation. And in that case, if it has notified to do so, and then if the employer has not objected, it can again claim compensation. And the last situation is where if time is not of the essence in a construction contract, then in those situations, if the employer has delayed in performing its obligations, then obviously the contractor can claim compensation for that delay. This is at least what comes out of Section 55. But as I said earlier, today in day and age, the construction contracts are obviously extremely detailed. They have detailed provision on what happens in various circumstances, whether there'll be delay plus extension of time, and how to deal with those particular aspects. So if with that, given the fact that there is what is given in the law in India provided within the statute, and given on this side what the contracts provide, we try and now sort of merge it and see how the cases in India have looked at these issues and how the law in India has progressed on this aspect through case laws. So the first case that we see is PM Paul versus Union of India. Now this is an old case, but it dealt with construction of a building. Here, there was obviously a delay in performance of certain conditions, which led to extension of time, or the contract could not be completed within the scheduled time. And the contract did not contain any price escalation clause. So there was a delay in handover of site, losses due to increase in prices of material and cost of labor and transport during the extended period of contract. And the contractor now claimed these particular costs, which it had incurred due to the delay. The court in such the situation ruled that, look, when there is no price escalation clauses in contract, in such circumstances, if there is delay which has taken place, and particularly as attributable to the employer, then the contractor is entitled to claim the price escalation or whatever loss or cost it has suffered due to the delay. So this was a situation where the contract did not include a price escalation clause. Next, we come to a situation where the contract actually included a clause which said in cases of delay, no compensation will be provided to the contractor. Now, in India, this is fairly common in context when one contracts with the government. There are very often these cases we come across. We see contracts where they are specifically agreed that delays will not be compensated for by the government. And such type of a clause in actually this case of Ramalinga Reddy, as you see on the screen, has been approved by the Supreme Court, and they have held that in such cases, any compensation for delay cannot be granted. A similar situation was also there in Ramnath International case before the Supreme Court. However, here the clause is very interesting. The clause here says if the work is delayed, and then it lists down multiple reasons. It says if the work is delayed, and A, B, C, D, E reason, and the last reason it lists down is by reason of any other cause, which in the absolute discretion of the accepting officer is beyond the contractor's control, then in such case, officer hereinafter mentioned may make a fair and reasonable extension in the completion dates. So the clause provides that in certain circumstances, if the reason for delay is beyond the contractor's control, then extension of time can be granted. However, at the same time, the clause went on to say, no claim in respect of compensation or otherwise, howsoever arising as a result of the extension can be allowed. So it also said that, look, while you can get extension of time, there will not be any claim which will be allowed. The court actually interpreted this last provision, which says by reason of any cause which is beyond the contractor's control, to include even those causes which were within the control of the employer, and said that, look, if there is any delay which is attributable to the employer, even in those circumstances, this clause C would bar any claim for compensation. Now, this is an unusual situation which arose where actually the employer, in this case, the government, is at fault, but the contractor is made to suffer, cannot claim any compensation or loss for it. There's multiple other cases which then started following the similar approach, which are again listed, such as the Buddha Raja case or the ONGC versus Weak Brothers case. Interestingly, there's also a contrary line of judgments which emerged or which exists. The first one in this was the Sarvesh Chopra case in India. And in this case, the court said that even if there is a clause which bars you from claiming compensation for delay, which is occasioned by the act of an employer, still a claim can be entertained in certain circumstances. And it lists down 3 circumstances. These circumstances are on the screen. And if you would note that the first and the second and third circumstances are same as those which are covered by Section 55 of the Indian Contract Act. Especially, or rather within Section 55, those circumstances where time is of the essence. So the court in Sarvesh Chopra actually applies Section 55 and says that in this situation, time will of the essence. And in that, and in those type of a contract, the contractor can indeed go ahead and claim compensation, even if there is a clause which says the contractor will not get any compensation on any delay occasioned by the employer. So now we have a situation which was there in the earlier case of Ramnath International, which was proceeding in another direction. And now we have a Supreme Court judgment which is saying that even if there is a clause, you can claim prolongation costs. Now comes the Asian tech case, and why this case we have put forth over here is that the clause which was in consideration in this case was exactly same as the clause there in the Ramnath International case. But here, the Supreme Court took a completely different view. Here, the Supreme Court held that even if the clause is there, it would not stand in the way of contractor claiming compensation for delay occasioned by acts of employer. So now we have a situation, clear situation, where the same clause in Ramnath International case has prevented the contractor from claiming losses, whereas in the Asian tech case, the contractor has been able to claim losses. Interestingly, thereafter, Delhi High Court identified this conflict and actually went in favor of the contractor. The Delhi High Court said that, look, the two cases are clearly going against each other, and then said that a clause, and then applied Section 23 of the Indian Contract Act to actually say that, look, a clause which bars you from claiming any loss for others' act or conduct or for a breach committed by the other is prohibited under Section 23, or is violative of Section 23 of the Indian Contract Act, and will not be enforceable. It rather said that those clauses which were there, or the clauses which were there in Ramnath International and Asian Tech case should have been interpreted differently to say that reasons beyond the control of the contractor would not include reasons within the control of the employer. And in this case, the court actually went ahead and said that they applied the principle in Asian Tech case, protecting the contractors and saying that if the delay is occasioned by the employer, then even though there is a clause in the contract which prohibits any claim by the contractor for such delay by the employer, the contractor can still go ahead and claim the loss suffered. And I'll come quickly now to the last case. I know I've been going on for a fairly long time, but with last couple of 2 more cases, and the idea over here is just to sort of highlight, and why I'm pointing out this case as the last part is that in this case, all the others have been discussed in detail, and they again differentiated from what was given in Simplex. And they eventually came to a position and said that even though Asian Tech has ruled in certain way and Simplex has gone in that direction, but still what is given in the contract needs to be seen. And they then looked at the contract, but found that the delay or the prohibition which was there given in the contract against the contractor from claiming losses did not apply, and then eventually rolled back to the position under Section 55. So the entire analysis which has been flowing so far has been in the way that you have a situation where you have Section 55 of the Contract Act. Thereafter, you proceed to these cases where you look at one end, you have these cases flowing in one direction saying that these exclusionary clauses will prevent a claim by the contractor. And then there are these other set of cases which don't allow, or which say these exclusionary clauses will not be given effect to. And eventually we have this case which says that you go back to Section 55. I think I'll probably not go on in the other cases because I think I'm exceeding my time by a fair margin. But I just want to conclude on a few points over here in context of Indian law. When you're looking at delay under Indian law, you should keep in mind Section 55 of the Indian Contract Act, and first sort of try and see with how that the consequences that Section 55 may have. While doing so, you should first evaluate if time is of the essence or not. And if time is of the essence, there are certain consequences which flow thereafter. And if time is not of the essence, then obviously there are certain other consequences which flow. Once you have done these two steps, you also look at your particular contract and then see what are those terms and what are the consequences which are flowing therefrom. If there are any exclusionary clauses which prevent a claim from a contractor, then you should keep in mind the direct effect of Section 55 and try and come back to that. I think with that, I'll probably put a pause over here because I know I've exceeded my time by a great margin, and probably go back to other speakers who are there on our panel and invite and bring in Hamish from HKA again. Hamish would would be giving us brief presentation on the subject of commercial damages in construction disputes. So with that, Hamish, I'll probably hand it over to you now.
Thank you, Ashish. I'll share my slides if I can, Rakesh. Okay. So hello, and thank you everybody for joining the presentation. It's great to be able to present to you. I will look at some of the elements of claims for commercial damages in construction disputes, and this will just be a very, very quick introduction to the topic. I'll look at this in three parts. What are the types of claims made in construction disputes? When can commercial damages be claimed? And if we have time, a few more examples. As an introduction, the basic principle of damages is to put the claimant back in the same position they would have been had the incident, such as a breach of contract, not occurred. There are a number of types of claims that may be made with regards to commercial damages. First, there is often a claim for wasted costs. This claim relates to costs incurred in reliance of or assuming that a contract would be performed, and these costs could include things such as salaries, cost of contractors, and also other costs. Second, a claim for loss of profits may be made. This relates to a claim for the profits that the affected party expected to earn had the contract been performed. Third, in relation to a delay of a construction contract, there's often a claim for additional financing costs to be incurred. This amount can actually be significant depending on the duration of the delay and the amount of funding used, particularly combined with the loss of profits, which could have been used to pay down the borrowings. Now, in our experience, the claims for loss of profits and additional financing costs are very common, for example, when the construction of a major project has been delayed. Lastly, in some cases, a claim may be made for the diminution in value of an asset or project. We typically see valuation-related disputes involving shareholders, joint venture partners, or even investor-state disputes. One key point to make is that there should not be any double counting amongst the various types of claim that can be made. For example, wasted costs and loss of profits are usually alternative claims. A second point is that the commercial damages could be significant relative to the additional cost claims, as shown in the graphic. However, this may not always be the case. I'll also briefly touch on liquidated damages. In relation to a claim for delay or disruption, many construction contracts include a liquidated damages clause. However, I understand that in some jurisdictions, the liquidated damages can actually be challenged by comparing the quantum of the liquidated damages to the estimated actual loss. And we have been engaged for this purpose before. On the next slide, I'll look at some of the potential scenarios that give rise to claims. As this presentation shows, claims in relation to construction projects often involve a delay or disruption to a project. Any delay in completing construction of a project or disruption to its operation can lead to a claim for commercial damages. In the context of a dispute, there are a number of possible scenarios forming the basis of a claim. A few of these include, first, a dispute between an owner-operator and the EPC contractor. For example, the owner may claim a loss due to the delay in construction caused by the EPC contractor. Second, shareholder or joint venture disputes may give rise to claims where one of the shareholders or the JV partner has caused a disruption to the construction or operations of a plant. We've also recently had a case where we needed to analyse the value of a project to determine whether the project had any value at all and whether it should have been cancelled or not. Another example involves investor-state disputes, where a foreign investor has entered into a project, for example, to supply electricity under a PPA. In one such case we worked on recently, the state had cancelled the PPA after it had already been agreed between the parties, causing a loss to the supplier. I think we just have time for a few other examples. So on this slide, I've listed a few recent cases that we have worked on. I'll just mention a couple of them briefly. So first, in projects such as the power plant projects we worked on and also the construction projects in the Philippines, we were appointed to quantify damages due to the delay in construction. And this analysis involved analysing the impact on profits and also the additional financing costs. As one final example, we were engaged in an investor-state dispute involving a construction project in Asia. In this case, the investor had agreed to and started construction of various projects, and in return, they would receive property rights as payment. So essentially, they would receive land. Now, in relation to the alleged breach of contract, we were engaged to quantify the loss based on the value of the property rights to be received as payment, less a deduction for the cost to complete the projects. Now, that's a very, very brief introduction to commercial damages, but I think that's all we have time for. Thank you very much.
Thank you, Hamish, for that. I think this is an interesting area, and probably we'll look more into this in another session. Probably we'll dedicate a full one to this. And the example that you gave is obviously interesting, and we would want to know more in terms of the outcome that came out of it. But with that, I think moving forward, I'd like to bring in my colleague Kamran over here to sort of discuss and explain to people the new issues that we are facing or we have seen in the construction disputes that we have handled recently, and sort of the new or emerging case law or trends in this particular space. Particularly sort of deriving from the experience that we have had over the past couple of years in handling some large-scale disputes. So with that, Kamran, would you help us with some of these sort of issues that we have faced and try to analyze?
Right. Thanks, Ashish, and welcome everyone tuned in. Basically you've raised the most lengthy topic for me, but I'll try and make it very, very quick and short because there are multiple issues which are being faced in construction disputes. But I'll just pick up the one which is most common across all construction disputes that we've seen. And that issue is basically with respect to claim notification. And this claim notification, and just one second, if I can just put my slides up on the screen so that it's better for everyone to follow. Ashish, can you see the slides up on the screen now? Right. So one of the most common issues that we face in construction dispute is the notice clause requirement, where a contractor is typically required to raise a claim within a specified period of time before the employer, and failure to do so may result in employer being discharged of all liabilities in respect of that claim. Now, a very common example of this kind of a provision is the FIDIC Silver Book 20.1. There are multiple variations of this clause which are found across all construction contracts. Now, typically, how will this be looked at in India by the courts here? The question and the way to answer that question would be to look at the Indian Contracts Act and see how the Indian Contracts Act will actually look at such a provision. Now, Section 28 of the Indian Contract Act, basically, which now provides Section 28B, that every agreement which extinguishes the right of any party or discharges a person from liability after expiry of a specified period so as to restrict a party from enforcing a right will be void to that extent. Now, interestingly, this section 28B was not there in Contract Act prior to 1996, 1997. And up until 1996, section 28 had only clause A, which provided that any agreement which bars a person from enforcing a right in the usual legal proceedings, or which limits a person's right to sue, which limits the time period within which a person can enforce his right, will be barred. So people, what they started doing is that they started tweaking their clauses, and instead of limiting the time period within which a person should enforce his right, they started extinguishing the right itself. And the contract started providing that if the claim is not asserted by a certain period of time, the other party will be entirely discharged of all liabilities. Now, the Supreme Court in 1994 also acknowledged that this is a problem. It was also picked up by the Law Commission. And in 1997, the Law Commission actually came forward with a recommendation and to do away with the economic injustice that was being done because of these kind of clauses. They have now inserted section 28. And the Supreme Court now, section 20, with this, the Supreme Court has now, in the IndusInd Bank, which is, I think, a 2016 case, held that both types of restrictions, whether it is limiting the time within which a remedy can be availed, or basically extinguishing the right in itself, will be void and will get hit by section 28. And there are multiple judgments from Delhi High Court and Rajasthan High Court which have followed suit. Now, a brief caveat over here is that there are a conflicting line of judgments from Bombay High Court also emerging on this issue, which hold that these kind of clauses will not get hit by section 28. And interestingly, the issue is still not settled at the Supreme Court level. Having said that, if one were to argue that these kind of notification clauses are not good or will get hit by Indian Contracts Act, there is a good force in that kind of an argument, because there is also section 70 of Indian Contract Act, which provides that a person which has enjoyed or who has enjoyed the benefit of a non-gratuitous act is bound to make a compensation with respect to that act. And therefore, this is a provision of unjust enrichment, which is which is recognized in under common law as well. So one could argue that this also gets hit by section 170. Another argument that can be made against this kind of a clause is that it's in the nature of penalty, that just because you've not asserted your right, do you give up your entire claim, which may be running into thousands of crores or hundreds of crores. Having said that, all is not lost on the other side also, because depending on how your dispute resolution clause is worded, and sometimes what we have seen is that the dispute resolution clause simply provides that only the notified claims go to arbitration. And if only the notified claims go to arbitration, then arbitrator is only a creature of contract. And therefore, arbitrator cannot actually go into claims which have never been notified. So all is not lost from the other side. And maybe this was one of the most common issues, Ashish, that I was facing, that we have seen, in the construction disputes space, and thought I would just touch upon it for the benefit of everyone here.
Thank you, Kamran. It's very helpful. Obviously, it's interesting to see how this has developed, and probably, at least in my experience as well, this is something that typically comes up in every case, particularly in the first bit, the notice provision. And this is something that Benjamin was also speaking of earlier, maintain strong contemporaneous record, and sort of following the notice provisions and clauses in the contract are of utmost importance. I think with that, we have only 10 minutes left, and we need to sort of hear from Parveen and Martin both. Probably I'll make a caveat here to all our audience and who is there today that we might overshoot by 5 to 10 minutes. And I know I'm the culprit for it, but I'll probably also sort of come in over here and request for that additional time from everyone who's attending. And so at this stage, Parveen, I'll come to you. Obviously, you have been in the industry, you have that experience, you've been there for over 20 years. We've been discussing top causes of claims and disputes. So being in the industry, and I know you come in from the developer space, but what are the top causes of claims and disputes, or rather delays as well, in the space that you are seeing or witnessing? Obviously, we know COVID has come and it has an impact as well, but what has been your experience so far?
Sure. Thank you. And it was interesting listening to everyone earlier and their viewpoint. I've been on the corporate side, mainly in the real estate infrastructure space. And to start with, I think a few facts of where we really are as a country. Our construction law is through very many statutes, whether the Indian Contract Act, the Transfer of Property Act, various labor laws. And this is leading to an uncertainty in the interpretation itself. And that is why we have disputes and the protracted litigation. The contracts itself are distorted versions of FIDIC, and there is no standardized format of the contract. Over a period of time, there have been certain amendments to try and address these issues, such as the Specific Relief Act, which was amended in 2019, where a civil court is prohibited from granting an injunction for infrastructure projects, where the injunction would result in a delay in the progress or completion of the project. There have been amendments even to the Indian Arbitration Act, but they still do not address the issues which are faced by the sector due to the complexity of the transactions and a lot due to the technological advancement which has taken place in construction, and therefore the evolvement of the dispute itself. If we come back again to the Specific Relief Act, there have been amendments which allows the victim of a breach to get the contract performed through a third party and recover those expenses from the original contractor. But that provision is again qualified and subject to Section 55 of the Contract Act, and Ashish and Mohammed have explained in detail how Section 55 itself works. Therefore, the recovery of any amounts through the Specific Relief Act, even though there is an amendment, does pose a challenge because of Section 55, and there are judgments on HIN construction, etc., which act as a hurdle in that. One particular problem that I think all developers, construction companies face in India is the use of substandard material in the construction of a project. So the rights of a company in such a case really depend on the terms and conditions of the agreement with the contractor, as well as the impact that can really occur as a result of the contractor's choice of materials. So a company really has a right to claim the monetary damages, but the same really depends on the interpretation, whether the contractor's choice of that replacement material renders it a completely different project, which is substantially different from what it was contracted for. It is only then that that breach is considered to be a material one. So that's where the real problem lies, where it starts right from the root, which is the contract terms itself. I have seen contracts in the US where there are provisions relating to mistake in bid, and therefore you're allowed to withdraw from the bid if there's a genuine mistake. In the Indian context, such provisions do not exist. There's been a lot of disputes relating to forfeiture of amounts because there have been errors in quoting, and there are judgments to that effect, and the entire provision relating to mistake in bid and all the disputes relating to that is not really addressed. The other area of disputes is over invoicing that was in a way covered as a cause. I know UK has the False Claims Act, and there are interesting provisions which penalize over invoicing, but that is absent in the Indian context, and therefore the disputes continue to be relating to over invoicing. The other segment of disputes in India are relating to the way contracts are drafted again, which there the milestone payments to the contractors are front-end loaded. So what really happens is that you're flushing them with funds more at the beginning, then they're not really deployed either for the payments of the materials that they were to be used for. And by the time you reach into the cycle of the project, especially in the construction infrastructure space, they do run into 7 and 10 years. The shortest is probably a 3.5 year cycle, and they're unable to comply with the obligations. The Middle East does have interesting provisions which permit a price balancing in a contract, again, absent in the Indian context. My colleagues did cover earlier on change in scope as being one major reason for a dispute in India. This is a lot due to each site being unique. Real estate laws in India are state specific with local issues. Approvals range anywhere between 70 to 40 approvals from government authorities without any single window clearance. Also, the requirement of the approvals for each site, there is no one particular repository by any government authority. So what really happens is the scope evolves as you start understanding the site better. And that's one of the main reasons why it does continue to feature. But what is the cause of change in scope, I think needs to be understood a little more to be able to arrive at that change in scope itself is a reason for dispute. It's related. So I'd say there have to be checks and balances, I agree, so that the project timelines are met, the costing is not impacted. When we draft the tender conditions, we really have to bear in mind that it's balanced, because the project should not get stalled. What typically happens is a lot of the clauses all lead into termination events. And that's really not the way any project is going to get completed, where everything is a termination event or everything goes into dispute and arbitration. There have to be liability clauses which should be a genuine pre-estimate of the losses that the company does incur. There needs to be an understanding of how the NPV and IRR of a project does get impacted when there is a delay in the performance. There is a time value of money while calculating the claims. And if that delay is attributable to the contractor, that means the collections from the customer or the amounts to be received from the employer, all of that get delayed because you're unable to perform that milestone. And that entire understanding needs to be factored in. A lot of times in the claim calculation that gets really missed out, which is a huge cost to any company. Excellent records, I do agree, because you do need the evidence. A lot of times it's a lot of communication on email, not really documented, and that does impact. I'd also like to add a point. The choice of law firm itself, when you get into arbitration, is a very important factor. Because a lot of times in an arbitration, if you have only law firms which understand only the law and don't understand the construction nuances itself, the result of what that arbitration could be, of how you have drafted, how you have argued, it completely changes, because a lot of these disputes are less to do with law, a lot to do with technical understanding, to be able to understand how to apply that law, to be able to manage that. So that's essentially where construction disputes are, as per my experience.
Thank you, Parveen. And I think some of the points that you echoed, or rather most of the points that you echoed, if I can put it down in 2 brackets, may come down to lack of standardized contract in India, or any standards contract frame. Each public department or each government or every other person using their own sort of standard forms and innovating in their own particular ways to come up. And in fact, we can see it in the arbitration clauses as well, that we see in the various government contracts in different places. And the other is lack of standard law in India, which applies to the construction industry. Obviously, there's a whole set of laws with the specific performance, the real estate RERA, or the Contract Act in general. But obviously, there's a lack of a standardized law, which we typically see in other leading jurisdictions. I see there are questions which have also come in for you, but before we go to those questions, I'll bring in Martin over here because we've been speaking about laws on construction. We're speaking about standardized contracts and how they can help in reducing disputes in this particular space, or sort of can be a way in which some of these issues can be resolved. Martin, obviously you've been working with RICS, or the Royal Institution of Chartered Surveyors, for over 30 decades and been researching in the space of ADR and best strategies to sort of resolve disputes. What has been your experience? Benjamin initially pointed out that adjudication is not something which is really common in Asia, and people are not so familiar with that process. But you work in UK, you've seen multiple other jurisdictions. What in your experience has worked? What has your research shown as effective strategies to resolve disputes?
Thank you, Ashish. I think to begin with, in answering that question, I need to say that the speakers so far all been very excellent, and they, with a reference to the HKA Crux report, really spotlight the extent to which disputes occur in the industry. There are immense amount of disputes, immense amount of causes of disputes. They cause huge amount of damage to the industry. They result in additional costs, the application of resources to deal with them, the application of time to deal with them, and all of this, of course, impacts negatively on project delivery. And so the answer to the immediate answer to the question about what our research is finding is that too many parties think about how to resolve a conflict, how to manage conflict too late. They think about it when the problem has already arisen, perhaps when the problem has already become entrenched, when lawyers have been, and apologies to all the lawyers here, lawyers have been employed, the parties have taken up positions, they've extended an immense amount of costs, the project itself has started to grind to a halt. And so part of the answer is that, and this is something we've learned in the UK, and we're starting to see a growing appetite now for industry, for employers and suppliers, contractors, right across the various tiers, to start thinking about how to manage and how to deal with conflict even before the contracts are signed. So they're looking at what can we do, and the first thing, of course, is to make sure they've got the right contract. And I think it was Pavina mentioned, or somebody mentioned the use of FIDIC forms, which may not necessarily be the right form for that particular project. They need to get the contract right. They need to be thinking, what happens if the problems start to arise? And I'm using the word problem rather than disputes at the moment, because disputes, to my mind, are very much the end product of problems that emerge, differences of opinion that are not dealt with soon enough and early enough. So really, how to manage and deal with conflict needs to be part of the early discussions before the contract's formulated and signed off. And then parties need to be careful, and they need to make sure that they have the right contract and they don't rush into it. So it needs to be part of their risk analysis. What we also are seeing now is encouragement from the UK government right across the industry for parties to behave responsibly. And the government, in fact, has been issuing guidance on responsible behaviour for contracting parties. And it talks about parties collaborating to try and manage and avoid conflicts as and when they can, and to take steps to deal with conflicts much earlier. So we've heard about case law dealing with disputes, we've heard about arbitration. They should be something that happens only as a last resort and not something that is normal. Adjudication has been used in the UK for the last 23, 24 years. It has proven to be immensely effective in dealing with disputes very, very quickly and very, very effectively, to the extent that far fewer cases end up in courts these days in the construction engineering sector than previously did in the early part of the 20th century. And it is an effective means. I appreciate it's not something that could be introduced straight away into Asia or into India. But I'm working currently with the Canadian government, for example, which has now really grasped the bull by the horns and is starting to implement adjudication provisions in Canada. I realise we're running short of time, and you did have, I think, a number of questions you want to ask me. And I did say when we were talking a couple of days ago, Ashish, that on each of these questions I could run a whole webinar. So I'll try and just stop when I can.
Sure. No, Martin, this is actually quite insightful to see. And as you said, the idea is to sort of start these discussions much earlier than actually what parties do. And we have actually seen in some of the cases that we have handled. And in certain cases, particularly where you're dealing with the government as a counterparty, there is also certain issues around, even if you initiate that conversation at an early stage, what are the consequences that you face? How fast does that conversation actually move? So those aspects also come in at that point in time. And it's very interesting to hear about UK and Canada on the laws that you described over there, because some of those, even pushing the government or other organizations in context of India, would be something which could be used or be helpful. Probably we'll come back to you again, Martin, but we see there are a few questions, as you pointed out. We'll take those at this stage. And if I'll probably start with the first one, which is here, which is from Deepak. Do we see any standard contract templates that may be issued for Indian market in near future? Is any effort taken in Indian law at this stage to address this issue of template creation? I can probably take the first shot, and then Praveen or anybody else, if they have any comments, please come in as well. At least we have not seen any standardization or many efforts done in different departments, or the government are still functioning differently. We do see certain international standard forms now being brought into India and being used in contracting in India. We have dealt with recently some disputes under the FIDIC standard forms, particularly in area where Indian government is sort of using the overseas development loans, and foreign contractors are coming in and sort of taking up projects in India. So with the entry of foreign contractors, we are also seeing international standard form contracts coming in, but at least at the local level, in your usual PWD contracts with other players within the industry, so forth, we at least don't see any such standard form templates or something like a commonality across various states and various departments and organizations. Parveen or anybody else, do you have any comments on this particular issue of standard form contracts, or anytime we'll see those?
Sure, thank you. I think, Ashish, we're a while away from a standard contract template format. What is first required is a unified construction law itself, in my view, which will then address, because no matter how we borrow templates from foreign jurisdictions and are using it now, it does go into disputes because of the quality of the substandard material and all the points that we spoke about. And we have the same law to again go back to interpreting it. So it really needs, as a priority, first a unified construction law, and a lot then will get addressed in the standard contracts, which can be evolved later.
Sure. I think there are two more questions, so we'll quickly try and address to those two, and then if there are any others, we can obviously come back to them later and try and respond to them in writing or through email or otherwise. The first one is, again, addressed to you, Parveen. It's basically, as you pointed out, that in certain cases, substandard material is used. In those cases, can there be any claim for diminution of brand value? And probably I'll also bring in Benjamin or Hamish if they have seen this type of situation which has arisen or not.
Sure. The brand value is a difficult one in arbitrations and all the that I have done. It requires that first you have to have valued your brand itself, then to show the loss to the brand, and to prove that is really difficult because it has to be actual losses. So while it is in a sense, I'd say theoretically added as a number, very difficult to prove and get in the Indian context. We've a long way to go till damages towards diminution and brand value is awarded at least. But Benjamin and Martin, anybody else, please?
Yeah, I mean, I think the lack of quality of materials is very much a construction issue, and it's dealt with by the contract. I mean, I suppose if it results in the project being delayed, which might affect the brand of the developer who've maybe sold the project or has advertised the project, then there's very much does talk to damages and commercial damages and loss of profits and those sort of things. It's not quite perhaps brand value, but there is a brand element to it. I don't know if Hamish has, from a commercial damages expert perspective, has a view on that.
I'll just comment very briefly. If there is some kind of financial loss, then we would be able to estimate the loss. But I can't comment as to whether, legally you'd be able to claim for it. So usually we work with the lawyers to understand the claim. But if there is some kind of loss in value, with a lot of analysis and careful consideration, we should be able to estimate that loss.
Yeah, I think under Indian law, what we normally apply the principles of reasonability and foreseeability and sort of identify how remote or whether we do it or not. And it's something similar to the English law case of Hadley versus Baxendale and the test laid down therein. Diminution of brand value due to supply of substandard material can be considered as something which has been direct or within the parties' reasonable foresight while sort of contracting with each other as a loss which may be caused, is another aspect which then sort of, as I said, on a legal side remains to be proven before such a claim is allowed. And I think this is something which Parveen had alluded to earlier. I think Martin wants to point out something over here. So Martin, please.
I just want to maybe just put this question into context, that in the 30 years I've worked at RSS and have been involved in something like 40,000 different construction disputes, the issue of brand value has never ever arisen as a part of a claim or as a counterclaim or as a defence. It's never been an issue in any dispute that I've ever seen.
Okay, interesting. So brand value is something which clearly not coming up as an issue in other jurisdictions.
That's a UK experience.
No, that's obviously good to hear. So, because typically we follow what the developments which take place in UK, even in terms of our jurisprudence or otherwise. So if that's not taking place over there, I don't think we'll see it anytime soon over here coming in directly. But obviously applying the Indian principles also, and even otherwise, we haven't seen such claims which have been allowed. And I think there are more questions coming in, but I'll take the last one and then probably close at this stage because I know we have exceeded our time by a fair margin. I think there was a question in the chat window as well, which was posted first. I'll just quickly go to that one, which was, doesn't all contracts are insulated by high cost while they estimate the tender in the first place? Do these disputes covered by any kind of insurance? Any of the participants want to comment on it, or should I?
Can I just make one comment?
Yes, please.
Just one very quick. Certainly what we see in the UK is that when contracts are being priced, there's always a contingency. And that contingency is very often related to the cover of potential disputes. Very often we talk to employers and contractors and they estimate that there will be a percentage of contract price which would need to go on legal spend, and that legal spend will be dealing with disputes. So it's not an insurance in the formal sense, but it's a kind of informal insurance that parties build in.
Sure. And in context of India, at least what we hear from our discussions with the industry players, the buffer that is maintained is actually very low. Because of the given competition which is there in the Indian market, there's actually very little profit or margins that the Indian sort of contractors are working on. So there is not much to go on. At least that's what has been our sort of what we have heard and seen from the industry players. And in terms of insurance, well, you have these solutions now coming into India. There are certain players, overseas insurers and others who have now sort of started providing dispute insurance in relation to disputes as well in India. So those options are now slowly becoming available, but are not yet popular or widely used in India as such. I think with that, I know there are more comments and questions and queries coming up, but probably we have crossed that time. What we can do is we'll take those questions and try and respond to everyone in writing post this webinar. At this stage, I would just like to now thank each one of our speakers over here for joining us today and joining this webinar and sharing their views, which were extremely insightful. I would like to thank HKA, the Royal Institution of Chartered Surveyors, and the Society of Construction Law India for sort of helping and collaborating with this event and sort of making this a success today. So thank you all, very obliged, and thank you for joining us. Very importantly, to all our participants, it was you who sort of made this a success and something that was for everyone over here. So thank you all to everyone who joined in. And just as a closing comment, this is initial sort of a webinar in this space. We would like to, or we would plan to hold more in this space. If there are any burning issues and there are any questions, subjects that you would like us to discuss in detail and try and address and bring together an expert audience such as one today to discuss those issues, to write to us, and we'll then try and put a program around it as well. So with that, thank everyone, and sort of bring this session to a close. And apologies, I think one aspect I missed out were the poll results. But my colleague flashed the poll results that we did today, and the sort of results are there on the screen for everyone to see. We will also share this on email with everyone. And so just to sort of highlight what's been the outcome and what the audience at least thought today, or the issues that they face. So with that, thank you everyone, and I'll probably bring this session to a close unless anybody else has any other comments.